So welcome everybody. People are sort of streaming in to the webinar bit by bit. I did know that a good number have signed up for this lecture tonight. I'm really excited about this lecture. This is another one of our series between Case Western Reserve University's Siegel Lifelong Learning Program and the League of Women Voters of Greater Cleveland, sort of celebrating, marking the 100th anniversary of the 19th Amendment, looking at the road to the 19th Amendment, what came before and what has happened since, and where do we still have to go. And we actually got the idea for this lecture during one of the previous lectures, one of the ones over the summer, where there were a lot of questions about the Equal Rights Amendment. And so I got in touch with the law school at Case Western Reserve to ask who is the one to tell us all about the Equal Rights Amendment? And Jonathan Entin was the one who raised his hand and said, that would be me, let me talk all about it. And so here we are tonight, and I'm really excited to have Jonathan here again. So Jonathan is the David L. Brennan Professor Emeritus of Law and Adjunct Professor in Political Science. The Emeritus is this is actually the second lecture that he's given to Siegel Lifelong Learning this semester. So retirement is not coming easily, I don't think. He taught constitutional law, administrative law, courts, public policy and social change, law and social sciences, law, legislation and regulation. I could go on and on and on. He served for almost 8 years as the law school's Associate Dean for Academic Affairs, has published more than 100 articles, book chapters, essays, reviews. He's won multiple teaching awards, including the Distinguished Teacher Award of the Law Alumni Association. He is a graduate of Brown and Northwestern, and especially sort of relevant for this evening, he was also a law clerk to then Judge Ruth Bader Ginsburg when she was on the U.S. Court of Appeals for the District of Columbia Circuit. And so I will turn it over to you. We're so glad for you to be here tonight and to learn all about the legislation around women's rights. So thank you so much.
Thank you, Karen. I'm honored to be here. Actually, my wife tells me that I haven't grasped the basic concept of retirement. Not only am I doing some of the things that Karen mentioned, I'm still teaching part-time. So anyway, now what I would like to do tonight is to set up some of the background for why the Equal Rights Amendment was proposed back in the 1920s. We all know that the Equal Rights Amendment was finally sent to the states for ratification in 1972, but not enough states ratified, so the Equal Rights Amendment has not become a formal part of our Constitution. But despite the absence of the Equal Rights Amendment, there has been substantial change in the constitutional law of gender discrimination. And so what I'd like to do is first to set up why there was the push for the Equal Rights Amendment, and then to talk a little bit about how lawyers like then Professor Ginsburg tried to work within the 14th Amendment, the Equal Protection Clause, to provide for some degree of protection against gender discrimination. Now, to do this, I'm going to start by putting up the 14th Amendment. Now, when the 14th Amendment was ratified in 1868, followed in 1870 by the 15th Amendment, which said that the former slaves and other people of color would have voting rights, nothing in either of those amendments spoke to women's suffrage directly, and as a result, there was a split among suffrage advocates. Susan B. Anthony and Elizabeth Cady Stanton opposed the Reconstruction amendments, the 14th and 15th Amendments. Lucretia Mott supported them. But let's take a look at why there might have been controversy among suffrage advocates. The 14th Amendment in Section 1 says that no state shall deny to any person within its jurisdiction the equal protection of the laws. Now that sounds like it might be a good piece of the Constitution to work toward gender equality. But then if you look in Section 2 of the 14th Amendment, we see for the first time that the Constitution would have a reference to gender. So Section 2 deals with the way members of the House of Representatives would be allocated among the states. This provision eliminated the notorious 3/5 compromise that was embodied in the initial Constitution. And it also said that whenever the right to vote for federal offices is denied for reasons other than having participated in the Civil War on the side of the Confederacy, right, then states could lose some of their representation in Congress. But notice that the reference is to male inhabitants, right? And so here for the first time, you see that maybe the Constitution is enshrining some degree of gender discrimination. Now, if we take a look at some of the first cases under the 14th Amendment, we'll see that those concerns really matter. So, for example, in the second case that the Supreme Court had under the 14th Amendment, a case from Illinois called Bradwell against the state. Sorry about the small size here, but this is Myra Bradwell. She applied for admission to the Illinois bar. The Illinois Supreme Court denied her admission, and denied her admission precisely because she was a woman. In particular, she was a married woman, and the state Supreme Court said, as a married woman, she did not have the legal capacity to enter into binding contracts. And that was the court's rationale. She took this case to the United States Supreme Court. The US Supreme Court affirmed the decision of the Illinois Supreme Court, essentially on that ground, that married women did not have the right to enter into contracts at common law, and therefore they couldn't enter into binding agreements with clients. That's bad enough, but there was a concurring opinion in this case by Justice Joseph Bradley, who has the reputation of being progressive, and maybe in some ways he was. But Justice Bradley went well beyond the majority's rationale to say that women, whether married or not, were simply not suited to the practice of law. And he said, among other things, the paramount destiny, admission, and mission of woman are to fulfill the noble and benign offices of wife and mother. This, Justice Bradley said, is the law of the Creator. So that rationale would keep all women from being lawyers. Things got worse from there. In 1908, Oregon had a law that limited the hours that women could work. That law was challenged by a businessman who relied on a case that the Supreme Court had decided just 3 years earlier that said that a New York state law that limited the hours that bakers could work was unconstitutional because it it violated the freedom of contract that the majority thought was embodied in the 14th Amendment. But in Muller against Oregon, that law limiting the working hours of women was upheld. Now, this is Louis Brandeis, back before he was on the Supreme Court. Brandeis was special counsel for Oregon, and he submitted a remarkable document. It's called the Brandeis Brief. It's about 115 pages long. It has 2 pages of legal argument and 113 pages of excerpts from studies that were supposed to show that women were fragile and therefore they should be protected against excessively long working hours. The Supreme Court relied heavily on the Brandeis Brief and emphasized a widespread belief that woman's physical structure and the functions she performs as a consequence thereof justify special legislation restricting or qualifying the condition under which she should be permitted to toil. So in other words, women were too fragile to work long hours, and reflecting the views of Justice Bradley in Bradwell, it would be dangerous for the future of the race, so to speak, to have women working too long because that would interfere with their childbearing functions. Now, we can talk about how it is that Brandeis made these arguments later on, but the fact is these arguments underscored the notion that women were fragile and different and deserving of protection. Now, sometimes courts refused even to take claims by women seriously. Good example is a 1948 case called Gossard against Cleary. That case involved a Michigan law that prohibited women from working as bartenders. There were some very narrow exceptions, but basically this law excluded women from being bartenders. The Supreme Court majority refused to take the claim seriously. The opinion says that this was one of those rare instances where to state the question is in effect to answer it. Right? Obviously not worth their time. The opinion went on to say that we cannot give ear to the suggestion that the real impulse behind this legislation was an unchivalrous desire of male bartenders to try to monopolize the calling. This, even though the law was passed right after World War II, when the men were coming home from the war. And if that wasn't the only rationale for the law, it was a pretty obvious one to suspect. But again, the court gives the back of its hand to the claim, doesn't take it seriously. And then we can jump forward yet again to 1961. This is the mugshot of Gwendolyn Hoyt. Gwendolyn Hoyt was married to a serial philanderer. She thought that he had agreed to straighten up and fly right, but he got involved with yet another woman, and she finally lost it one night, and she beat him to death. She was tried in a Florida court where, under state law, it was practically impossible for women to serve on juries. Gwendolyn Hoyt actually had a lot of trouble finding a lawyer who was prepared to argue that this Florida law was an unconstitutional form of gender discrimination. She did finally, but when the case got to the Supreme Court, without much difficulty, the Supreme Court upheld this Florida law and did so, it said, because women were rightly regarded as the center of home and family life. And that meant that it was perfectly fine for the state to treat women as jurors differently than it treated men. So notice where we are. The 14th Amendment is ratified in 1868. Here we are into the 1960s, and the Supreme Court has never found any form of sex-based law or policy to be unconstitutional under the Equal Protection Clause of the 14th Amendment. And that is why we got the push for the Equal Rights Amendment, which is pretty straightforward. Here it is, right? Equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. That's the operative language. The Equal Rights Amendment had been introduced in Congress in 1923. It finally got approved by 2/3 of both the House and the Senate in 1972, went out to the states, as I said, never got the required number of ratifications. I think it came up about 3 states short by 1979. There have been occasional efforts to revive the Equal Rights Amendment, but it's still not part of the Constitution. And so what we have is a Constitution that contains no explicit protection against gender discrimination, but the Constitution does contain this provision about equal protection of the laws. And so in the late 60s and early 70s, a group of lawyers around the country began to work on efforts to get the Supreme Court to treat gender discrimination as constitutionally problematic. This is a picture of then Professor Ruth Bader Ginsburg. She was teaching at Columbia Law School, and she decided that a carefully designed litigation campaign might eventually persuade the Supreme Court to treat gender-based discrimination as equally suspect with racial discrimination. Now, she never quite succeeded, but we will see that she and other lawyers working independently were able to get the Supreme Court to recognize that gender-based discrimination was in fact constitutionally problematic. Now, the first of these cases that got to the Supreme Court is a case called Reed against Reed. This is Sally Reed, who was the challenger. Basically, what happened in this case was that Sally Reed and her, by then ex-husband, had a son. And the son, as a teenager, got very depressed and committed suicide, leaving behind a tiny estate worth a few $100s. Both parents applied to the probate court to administer the estate, but Idaho, where the Reeds lived, had a statute that said that the probate court had to prefer men over women in appointing administrators of estates. And for that reason, and that reason only, the probate court appointed the father rather than Sally Reed. This case got to the Supreme Court, and although the court's analysis is a little sketchy, the court said that this gender-based law was unconstitutional. This is 1971, more than 100 years after the 14th Amendment was ratified. This is the very first time that the Supreme Court had struck down any law or policy as being an unconstitutional form of sex discrimination. And that was a really significant development. A couple of years later, we get another case called Frontiero against Richardson. This is Sharon Frontiero and her husband, Joseph. Sharon Frontiero was an Army officer. And as an Army officer, she put in for housing and medical benefits for her husband, Joseph. Now, if the situation had been reversed, if Joseph had been the Army officer and Sharon had simply been the wife, Sharon automatically would have qualified for those benefits. But because Sharon was the officer and Joseph was the husband, he couldn't qualify for these benefits unless he could prove that he depended on Sharon for at least half of his support. That reflected a federal statute. Professor Ginsburg actually argued the case on behalf of the Fronteros, and the Supreme Court said this law was unconstitutional. The court didn't quite apply the high level of scrutiny that Professor Ginsburg wanted the court to apply, but several justices were willing to do that. Other justices said that the law at issue here that required the husband to prove that he depended on the wife for more than half his support, that reflected the same problem the Idaho law had. And so Frontero again is another step along the way here. Now, getting ahead of myself, let me come back to the Fronteros. In 1974, there was a case from Cleveland Board of Education against LaFleur. The Cleveland School Board had a rule that said pregnant teachers had to stop working at the end of their 4th month. That law was challenged as an unconstitutional form of gender discrimination. The theory was it applied only to women, it limited their ability to work. When the case got to the Supreme Court, the court had a lot of trouble with this theory, and I'll come back to that later in the talk. But instead of directly addressing the pregnancy discrimination claim, the court said, well, the rule was unconstitutional. And it was unconstitutional because it required every pregnant teacher to stop working at the end of her 4th month, even if she was still capable of doing her work. And on that basis, and that basis only, the court struck down the Cleveland School Board rule. Then in 1975, we get a case called Weinberger against Weisenfeld. Justice Ginsburg always used to say that Stephen Weisenfeld was her favorite client ever. This is Stephen, and this is his son, Jason. Basically, what happened was that Stephen Weisenfeld was married to a woman named Paula Polacek. She died in childbirth, delivering Jason. Stephen Weisenfeld put in for survivors' benefits under the Social Security Act. There was a provision of the Social Security Act that said that widows with small children automatically qualified for survivors' benefits. But widowers, like Stephen Weisenfeld, with small children, did not. The Supreme Court wound up saying that this provision rests on archaic and overbroad generalizations about the roles of men and women, and therefore it was unconstitutional. A couple of years later, in a case called Califano against Goldfarb, the Supreme Court struck down another provision of the Social Security Act that provided survivors' benefits to widows, but required widowers to prove that they had depended on their wives for at least half their support in order to get survivors' benefits. This is a more general provision than the one at issue in Weisenfeld, but it's phrased in the same terms as the statute applicable to members of the armed forces that was struck down in Frontero. And the court again said that this law was based on unconstitutional, archaic, and overbroad generalizations and had to go. But throughout all of this period, the court had struggled to come up with a legal test for how to evaluate gender-based classifications, and it hadn't agreed on one until a case called Craig against Bourne in the mid-70s. Craig against Bourne is a very peculiar case. Oklahoma had a law that said in order to buy near beer, that is beer that had no more than 3.2% alcohol content, in order to buy near beer, you had to, if you were a man, you had to be 21. If you were a woman, you could buy near beer at 18. So a group of guys at Oklahoma State University sued, claiming that this law was a form of unconstitutional gender discrimination. This is actually not one of the guys, obviously. This is a woman named Carolyn Whitener. She owned a package store near the Oklahoma State campus, and she joined the lawsuit. Her theory was that this statute hurt her business because the guys, the 18 to 20-year-old guys, could not come in and buy near beer themselves. Fortunately, because the students turned 21 during the course of the litigation, the Supreme Court said, it's fine, we'll let Ms. Whitener carry on the claim here. And the court in this case said, not only is this age differential unconstitutional, but it gave us a formal legal test called intermediate scrutiny. This is a verbal formula. It basically says that a gender-based classification must be substantially related to an important governmental interest. That's, in theory, less rigorous than the test that the Supreme Court uses for racial classifications, where basically the court says classifying by race has to be essentially the only way that the government can promote a compelling interest. Now, we can make a lot out of these linguistic differences, but it's at least worth noting that intermediate scrutiny, as we got it in this case, turned out to be pretty robust. Oklahoma defended this differential, the age differential for men and women, by saying that the arrest rate for 18 to 20-year-old men for driving under the influence of alcohol was more than 10 times the arrest rate for DWI for 18 to 20-year-old women. On the face of it, that would seem to be a pretty plausible argument, but the Supreme Court had none of that. The court said, number one, the state defines near beer as non-intoxicating, so it doesn't make sense to be using DWI arrest rates as a proxy for anything. And second, the court said that we have some reason to suspect that the differential in arrest rate doesn't have to do with the fact that women are, in fact, less likely to drink and drive, but rather because either women are going to get driven by men, or if they are pulled over, the police officer is less likely to charge a woman with DWI than to charge a young man. Now, however that may be, the point is this shows us that intermediate scrutiny could be fairly rigorous. Now, it's also worth noting that this is a case involving discrimination against men, and I will come back to that in a few minutes. Let me just move on to a couple of more cases along the way, and let me be clear, then Professor Ginsburg was not involved in all of these cases, but she was involved in a fair number. The next case that comes along is a case called Mississippi University for Women against Hogan. This is a 1982 case. By then, she is no longer Professor Ginsburg, she is Judge Ginsburg. In fact, this Mississippi University for Women against Hogan was decided during my clerkship for her on the DC circuit, and I know she was not involved in the case at all. Basically, Mississippi University for Women was one of the few single-sex public universities in the United States at the time. And there was a guy named Hogan, who Columbus, Mississippi, which is where the MUW is located. Mississippi University for Women has a nursing school. Hogan wants to go to the nursing school. He's denied admission because he's male. The Supreme Court, in an opinion, by the way, written by Justice Sandra Day O'Connor, says you've got to have what she called an exceedingly persuasive justification to satisfy intermediate scrutiny. She said the idea that you need to protect opportunities for women in a nursing school doesn't make a lot of sense because, after all, nursing is an overwhelmingly female field. So we're just reinforcing stereotypes by saying that nursing is a woman's job and shouldn't be one pursued by men. The other problem Justice O'Connor identified was Hogan couldn't be enrolled as a degree candidate under the university's policy, but he could audit the classes. And so, to the extent that having women-only classes would help women's educational development, having even a male auditor would undercut that rationale. So this case raises some questions about sort of how far to read it. And we get a better sense about this in 1996 in a case called United States against Virginia. This is a case in which the Supreme Court, in an opinion by Justice Ginsburg, strikes down the male-only admission policy of the Virginia Military Institute. Justice Ginsburg's opinion for the court applied a pretty rigorous form of intermediate scrutiny that emphasized the exceedingly persuasive justification language that Justice O'Connor had used in Hogan. Rejected the state's claim that having a male-only admission policy at VMI promoted educational diversity because, the court pointed out, Virginia doesn't provide single-sex education, higher education for women, only for men at VMI. The state also had said that VMI had a distinctive approach to education. It's called the adversative method. Basically, what it means is that they treat the students like dirt. The state said women aren't going to be interested in this kind of program, so it makes sense to keep them out. Justice Ginsburg and the majority of the court said, wait a minute, the equal protection right is personal. The issue isn't whether many women might thrive at VMI, it's whether any woman could thrive at VMI, especially because most men probably wouldn't want to go through the adversative method either. Now, this is an important case, both because it applies a pretty rigorous form of judicial scrutiny to a gender-based classification, but it's also interesting because Justice Ginsburg got to write the opinion. Chief Justice Rehnquist, who, by the way, generally was skeptical of gender discrimination claims, Chief Justice Rehnquist wrote his own separate concurring opinion that basically agreed with everything that Justice Ginsburg had said, although he wasn't prepared to go quite as far in his analysis as she did. But what's notable about this is that the chief, by virtue of being in the majority, could have taken this case for himself. The Chief Justice gets to assign the opinion of the court in every case in which the chief is in the majority. And it is, I think, significant that the Chief Justice gave this assignment to Justice Ginsburg. Now, a couple of other things to note about this case. One is that the last piece of the opinion said, well, the state said, even though we don't allow women to attend VMI, We do have an alternative program called the Virginia Women's Institute for Leadership, VWIL, that is run at a private women's college about 40 miles from VMI. And the Supreme Court said, and this was both in Justice Ginsburg's majority opinion and Chief Justice Rehnquist's concurrence, that that alternative program was not substantially equal in many ways to the program at VMI. And for that reason, the state couldn't defend on the basis that it was giving substantially the same opportunities to women through VWIL as it was giving to men at VMI. So if you think about where we have come from Reed to VMI, the law of gender discrimination looks dramatically different by the end of this run of cases than it did by the time, or at the time that the litigation campaign started around 1970. Now, there were losses along the way. One notable one, a case written, by the way, by then Justice Rehnquist, called Michael M. against the Superior Court, upheld California's gender-based statutory rape law. Under the California law, it was a crime for a person to have sex with an underage female, but it was not a crime to have sex with an underage male. The court's rationale, well, women are at risk of becoming pregnant. The state, therefore, was allowed to act, to pass this statute that was, the court said, designed to reduce the risks of teenage pregnancy. And there were some other losses along the way as well, but I don't want to dwell on them now. I do want to come back, though, to the notion that some of these cases, like Craig against Warren, involved relatively trivial issues. I mean, after all, who would go to the barricades for the right to buy near beer at the age of 18 instead of 21? And that case and some of these others seem to be benefiting men. Think about Stephen Weisenfeld. Think about Leon Goldfarb, the widower in Califano against Goldfarb, right? So the question is, how do these cases brought on behalf of men promote women's rights, undercut discrimination against women? Well, there's a couple of answers to that. Justice Ginsburg always used to say that she thought there were two reasons for using male plaintiffs in some of the cases. First, as a tactical matter, she was trying to appeal, and the other lawyers were trying to appeal to the Supreme Court, which at that time consisted of 9 older men who presumably had relatively traditional views about gender roles. And so using male challengers would maybe help the justices relate to the argument. They could see perhaps that when we have traditional gender roles that are based on archaic and overbroad generalizations, maybe those gender-based rules that limit women's opportunities also in some ways restrict men's opportunities. Stephen Weisenfeld, for a good example. And also, some of these cases, like Frontiero, like Goldfarb, even like Weisenfeld itself, we're dealing with married couples. And you could ask, well, who's the victim here, right? At one level, we could say that Leon Goldfarb and Stephen Weisenfeld and Joseph Frontiero are the victims because they're being denied benefits, or they're being they're required to make a stronger showing to qualify for certain kinds of benefits than a woman would be required to make. But we could also say that the women in these cases are also being hurt. Sharon Frontiero is not going to get the kinds of benefits that a male married officer would get. Stephen Weisenfeld is not going to get the survivor's benefits that say Paula Polachek would have gotten if she had survived and Stephen had died. Hannah Goldfarb's working earnings were devalued because her husband, the widower, would not necessarily obtain benefits that she could have gotten if he had been the one who died first. So this begins to illustrate the complexities of talking about gender-based discrimination. Now, there are a couple of more things that I want to talk about before we open up for questions. One has to do with pregnancy. We've already talked about Lafleur, where the court, instead of treating this pregnancy rule as gender-based, treated it as arbitrary because pregnant teachers who were physically able to keep working after the 4th month were prevented from doing so. There was another case decided the same year. It's called Geduldig against Aiello. That case upheld the exclusion of pregnancy benefits from a state-run disability program. And the court said this is not really a gender-based policy at all, even though the program did cover some male-only disabilities like prostate cancer and prostate treatments. But the court said this is not a gender-based classification between women and men. It is a neutral classification between pregnant women and non-pregnant persons. Now, you say that seems pretty hilarious when you think about it. I mean, and we all know that only women can become pregnant, but it does illustrate one of the real challenges here, which is that the constitutional requirement of equality means that the government should treat similarly situated people alike. Well, if only women can become pregnant, then maybe men and women are not similarly situated for purposes of equal protection, or at least for some forms of equal protection. Indeed, the Supreme Court has consistently had trouble with pregnancy-based rules, not only these two cases, but in 1976, the court ruled that pregnancy discrimination was not sex-based and therefore was not a violation of Title VII. Congress changed the law in that, passed the Pregnancy Discrimination Act, so at least that problem has been dealt with, at least to some extent. But we still have this basic question about how do we think about pregnancy and the capacity to become pregnant in equality terms. One more issue that we need to think about that maybe raises some questions about how the Constitution can protect against gender discrimination. There's a 1979 case called Personnel Administrator against Feeney. That's a case that upheld an absolute veterans preference on Massachusetts civil service exams. Here's the way it worked. If you were a veteran and you got the minimum passing score on the civil service test, you went to the top of the list, even above a non-veteran who had a perfect score on the list. As a practical matter, because virtually all veterans at the time were men, as a practical matter, women who were applying for civil service jobs could not get civil service jobs except as nurses, secretaries, and similar sorts of traditionally female positions where men were not interested. The Supreme Court rejected a constitutional challenge to this absolute veterans preference because the court said the plaintiff had not proven that the state had intended to discriminate against women in adopting this preference. That's a more general kind of legal doctrine. And basically what it means is that if you have some kind of law or policy that has a significantly disproportionate impact on women, unless you can prove that the policy or the law was adopted for the purpose of discriminating against women, there's no constitutional claim. Now, that case is out there, the pregnancy cases are out there, and this brings me back around to the question, what would the Equal Rights Amendment have done? It's not necessarily clear. We don't know, of course, it was never, the Equal Rights Amendment was never ratified. We don't know how the Supreme Court would have interpreted the Equal Rights Amendment. But given its difficulties, its stumbles with pregnancy, and given the intent requirement, it's just a question about how much difference the Equal Rights Amendment might have made. We could talk about that. One more thing that we might also want to conclude on with all of these questions and qualifications. I want to come back to the pregnancy point. Only women can become pregnant. What follows from that? What does gender-based equality mean? Does it mean that we should treat men and women the same? Or should we treat men and women at least sometimes differently where there are relevant differences? There's not a clear answer to that question. People have been debating that for a long time. I think this is probably a good place to stop and open up for questions, and maybe we can get into some of these issues and some others as we go along. Okay, now question that just flashed up here, Karen, that I saw: state constitutional amendments that protect against gender discrimination. Yes, there are a number of states that explicitly prohibit gender-based discrimination. But those will help primarily when you're dealing with state law issues. Right? If you are dealing with a federal policy, the state constitution doesn't help you all that much. Now, if you are challenging a state policy, yes, you could in fact rely on the state constitution, but there might be some strategic advantages to being able to proceed again on a federal basis, because the U.S. Supreme Court, for example, is not going to decide what a state equal rights amendment means. It's only going to decide federal law issues. So if you want to have bigger impact, then having a federal guarantee is an advantage. As a lawyer, I would say if a client comes to me with a gender discrimination claim, the client's interest is in getting the gender discrimination claim recognized, getting the discrimination remedied. It's less important exactly what legal theory we use, but in terms of the big picture, having federal constitutional protections against gender discrimination will have a bigger impact than having a state constitutional protection against gender discrimination.
So I can read them out loud to you if that would be helpful.
Sure.
So the next question is, did public opinion have an impact on judicial opinions in equal rights cases?
That's hard to say. It's always hard to say exactly what role public opinion might play. But we should recognize that During the 1970s, when the litigation campaign against gender discrimination was going on, other things were happening too. I mean, the campaign for the Equal Rights Amendment was out there. Meanwhile, there were federal statutes that prohibited gender discrimination. For example, Title VII of the Civil Rights Act of 1964 prohibits employment discrimination based on sex. Now, there's a nice story about that, because the original bill didn't include sex as one of the prohibited grounds of discrimination. That provision was proposed initially by some Southern segregationists who were trying to sink the entire bill. And one plausible version of history was they proposed it as a poison pill, but it turned out that there were some women in Congress, like Martha Griffiths from Michigan, who said, wait a minute, this is not a poison pill. This is a real issue. We ought to accept this. And that's ultimately how that part of Title VII got added. There were other things going on that promoted gender equality. Now, exactly how that influenced what the Supreme Court was doing, that's harder to say. I mean, in Frontiero against Richardson, for example, 4 justices endorsed the strict scrutiny for gender classification. That's the most rigorous form of judicial review. 4 is only a minority, right? There was a separate opinion in the case that specifically referred to the Equal Rights Amendment and said, this justice said, I agree that this law that treats, that makes it harder for husbands of Army officers to get these benefits than for the wives of male Army officers. I agree it's unconstitutional, but I don't think we have to apply any particular standard of review here, because the Equal Rights Amendment is out there, and presumably if it gets ratified, that will tell us what the country means. So in a way, maybe the idea of public opinion making a difference, maybe it hurt in that situation, although there may be other places in which maybe it pushed in a more positive direction.
The questions are pouring in now. Did Louis Brandeis support women's suffrage and the 19th Amendment?
Yes, and let me just come back. Let me come back to this. Mm-hmm. In fact, Brandeis's daughter was a very good lawyer who ultimately became a judge in New York State. So, I mean, the fact that Brandeis wrote this reactionary sounding brief about gender rules, I think probably did not reflect his true views about the roles of women. But I think we could nevertheless say Justice Brandeis was not focused on that question, really. Justice Brandeis was outraged by that 1905 decision that said that it was a violation of freedom of contract to limit the working hours of bakers and presumably lots of others. And so Brandeis was looking for ways to chip away at that decision. This Oregon law comes along, the state asks him if he will defend it. And my sense is that he made the arguments that he made because he thought that that was a way to undercut the 1905 case. I don't think he was primarily concerned that he would be cutting off women's employment opportunities. But I think we can say, in retrospect, that the arguments that he made provided support for a whole raft of these so-called women's protective laws that ultimately limited women's employment opportunities in many respects. But I think my sense, and there are folks who have a different take on this, but my sense is that this was kind of an unintended consequence of a larger point. But I know that Brandeis has been strongly criticized by other scholars who have attributed to him pretty regressive views about women's roles. As I said, I'm a little skeptical about that, but I don't have definitive proof. But that's my my interpretation, and I'm open to others.
Another history question. What is the evolution of female support or opposition to the ERA?
Oh my.
What time is it?
How long do we have? Part of the, well, most of the support for the ERA all along came from women. Women who wanted to get the 19th Amendment ratified, right? Women who thought that we shouldn't have had to wait for the 19th Amendment. But there's always been a divergence of views among women. Probably the most prominent female opponent of the Equal Rights Amendment was Phyllis Schlafly, who did not live up to a lot of the stereotypical views of the shy, retiring housewife who was the center of home and family life. But she made a series of arguments that others made, to the effect that the Equal Rights Amendment could hurt women who didn't work in particular, because it might undercut the rationale, say, for alimony or child support. There were, of course, the arguments about combined bathrooms and the invasion of privacy, things that we see now in the transgender context. And to the extent that those arguments resonated, that they were able to mobilize women in opposition to equal rights, who some of whom were concerned that they were essentially buying the proverbial pig in a poke, and that maybe, although in theory that this would protect women, maybe in the end it would hurt at least some women, and that was a bridge too far for them. I think it's really hard to generalize too much here. A lot of the arguments were kind of opportunistic, and sometimes people would change positions when it suited their interests. Let me give you an example. My wife and I lived in Phoenix for a time in the 1970s, and while we were there, a very conservative woman member of the Arizona legislature introduced a bill that would have required married women to take their husbands' last names. The bill failed. A few years later, she got married. She hyphenated her last name. Mm-hmm. So go figure.
Go figure. Let's see. Jennifer asks that she's heard a debate that the ERA can't be ratified now as there was a statute of limitations. I would imagine that is the case. Otherwise, there would be a push to pass it in the last 3 states. Is that the case?
Well, there in fact has been a push. When the Equal Rights Amendment was sent out to the states for ratification, it contained a provision that said that it had to be ratified by 3/4 of the states within 7 years of submission. Mm-hmm. The 7 years came and went. There were only 35 states. There was an effort in the 1980s, and there have been proposals more recently to revive the Equal Rights Amendment to build on the 35 states. Mm-hmm. I don't know that has been litigated at this point. The argument that you could revive the Equal Rights Amendment is that somehow the 7-year ratification deadline was not as important to the process as it might appear. Indeed, the requirement of ratification within 7 years is a comparatively modern phenomenon. The most recent amendment to the Constitution, the 28th Amendment, which prohibits congressional pay raises until there's been an intervening election, that was proposed, I believe, in 1792. It had no ratification deadline. A number of states ratified it over the years, but not enough. And sometime in the 1980s, somebody rummaging around discovered that this thing was out there, and they got enough additional states to ratify. Ratification were sent in to the National Archivist, who said, well, there's no time limit. And so okay. And so the concern is that if you have too long a time period, that maybe some eccentric proposal or something that seemed eccentric, it seems eccentric now, but it had some support earlier, that somehow it could sort of rise from the dead and come back to bite us. So I think at this point, we can have an interesting discussion about this, but I mean, let's be realistic. Given the current composition of state legislatures, the likelihood that we could get 3 more states that have not already ratified to do so at least in the near term, seems remote.
Mm-hmm. Yeah. Another question, what are the current judicial cases that we should be studying right now in the area of equal rights?
Well, it's interesting. I think that there aren't a lot of constitutional cases involving gender discrimination straight up. A lot of the cases that may have that may bear on this are actually reproductive rights cases, right? And this is an area where Roe against Wade and Planned Parenthood against Casey talked about abortion and reproductive rights in terms of a right of privacy, a right of personal autonomy. But you see a little bit of this in Casey. The idea that the ability to control fertility and reproduction is not just a matter of individual autonomy. It actually goes to the women's opportunities. And restrictions on reproductive autonomy might be viewed in terms of gender equality. Justice Ginsburg used to say that. She wasn't the only person who did. It's not clear that how much that approach resonates judicially at this point, but a large part of the controversy surrounding reproductive autonomy and abortion rights does have to do with different views about women's roles. There are undoubtedly other hard questions involved, but that's in there. The other thing to keep in mind is that many of the gender discrimination issues that come up today don't really come up as constitutional claims. They come up as statutory claims. So, for example, the reason that LaFleur was litigated as a constitutional case was because school teachers were public employees. And at the time that the case was being litigated, Title VII excluded public employees or public employers from coverage under Title VII. So those teachers had no alternative. They had to go under the Constitution because they couldn't proceed under the statute. Title IX, the gender equality in education, is a statute, right? Now, sure, you have educational institutions that are public and are therefore subject to the Constitution, but Title IX, Title VII apply to the private sector as well, and at least at this point, this has been true for 50 years, you don't have to prove discriminatory intent under some of these statutes. In some circumstances, you could proceed on the theory that some practice that you're challenging has a disproportionate impact, and that could be enough to win in some of these cases. So again, if we want to think about this in terms of legal strategy, lawyers, if they have a choice between proceeding under a statute or proceeding under the Constitution, they might find that the statute is a more advantageous way to proceed. So you won't see as many constitutional claims. I don't mean you won't see any, but the significance of constitutional claims might be a little bit less, precisely because the law is now much more favorable. The statutory law and administrative regulations now are much more supportive of gender equality than had been true 50, 60 years ago.
Yeah. Maybe time for one more question. In your opinion, which of the Ginsburg cases in this area should the layperson study? Which ones are the most significant or the more interesting, do you think?
Well,
interesting.
I'm biased in multiple ways. One, as Karen said, I did clerk for her after after she went on the bench. I will tell you that one of the reasons that I applied to clerk for her was precisely because she had been involved in all of these cases a lot of these cases that we've talked about. I know that she always thought that Wiesenfeld was her favorite client, precisely because this was a case that stood a lot of gender roles on their head. I mean, Paula Polachek was the breadwinner. And I mean, he was a graduate student, I think. I mean, but she dies tragically in childbirth. He has all the challenges that single mothers traditionally had in terms of childcare and housekeeping and all of those things. And so that was the case, I think, that was most directly challenging of the archaic and overbroad generalizations. And so I think that's actually that was her favorite case. But in some ways, Reed is the really key case, even though in some ways it's a small potatoes case involving a really tragic family situation. That was the very first time the Supreme Court had ever found some kind of law or public policy that was based on gender to be unconstitutional. When you have 100 years of nothing to work with, and that's basically what we're talking about. The first case, however small it seems, however superficial the court's analysis may be in retrospect, being first really matters.
Yeah.
That laid the foundation for everything that followed, because if Reed had failed, it would have been a lot harder to win any of the later cases.
Yeah. Right. I think that's a great way to end it. Thank you so much. This was exceptionally interesting. I learned so much tonight, and I'm sure everybody else did as well. So thank you so much for taking this time out of your Thursday evening, and thank you, and thank everybody for being here, and thank the League of Women Voters of Greater Cleveland for co-sponsoring the lecture series, and we will see you for the next one. So thank you.
Thank you. Take care.